Hello everyone. The topic we will discuss in this lecture is from Jurisprudence, and the name of the topic is liability. The meaning of liability, or we can say what is liability, we will discuss in this lecture. So let me cite one example here. Okay, let's say A is an individual. A is an individual. A as an individual is having the rights. One of the rights A is having is a right to life as one of the fundamental rights. Let's say there is another person B. If B wants to kill A, then the right to life and other rights of A got infringed by B. So what duty B is having towards A? To protect the rights of A by not infringing A's rights. If let's say B injured A, then we can say B violated the law, and as liability is the result of a violation of the law, B will be liable in this regard. And in this example, B will be punished as per criminal liability by criminal proceeding. So we can say law lays down the rights and duties on the individual. We all have right to life, but at the same time we all have the duty to protect the right to life of others. The law awards legal rights to one individual and imposes the duty upon another person, which we have seen in the example just now we have discussed. A person should not infringe the legal right of others, and if anybody violates the legal right of others, that person is said to have committed a wrong. When there is a wrong, what there will be? If there is wrong, there always will be liability. If there is wrong, there always will be liability. So many jurists tried to define the term liability, but it seems their attempt to define the term liability, it did not work that much, as liability as a term is very hard to define. Okay, it is very hard to define. Now, according to Salmond, liability or responsibility is the bond of necessity that exists between the wrongdoer and the remedy of the wrong. So in this definition, the definition given by Salmond, so first we have to focus on bond of necessity, and then we have to focus on the words like wrongdoer and the remedy of the wrong. So who is a wrongdoer? This is the first question. Who is a wrongdoer? A person who commits wrong is the wrongdoer. Now let's say B committed a wrong. As suppose B has stolen a valuable necklace of which A was the owner. So the wrongdoer here is B, and the remedy will be given to whom? The remedy will be given to A, as A here is the aggrieved person or the aggrieved party. How the remedy will be provided? Now this is the question. By punishing B, who is the wrongdoer. Like the remedies we are having in Indian Penal Code, section 378, which is talking about theft. And there are other legal remedies also. Like when it comes to theft, the remedies here will come as a punishment for theft, which is getting covered by section 379 of the Indian Penal Code. Whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Okay. So as per the definition given by Salmond regarding liability, we can say in one hand we are having the wrongdoer, in the other comes the remedies for the wrong. Like as we have cited the example of punishment for theft under section 379 of the Indian Penal Code. So we can say if there is a wrong, there is a liability. Here liability of the wrongdoer will come as 3 years of punishment, or with fine, or with both in this example. Now let us look into the definition given by William Markby. Sir William Markby was an English judge and legal writer. Now, according to Markby, the word liability is used to describe the condition of a person who has a duty to perform, whether that duty is primary one or secondary or sanctioning one. So in this definition, you find here three important terms as far as the definition of the term liability is concerned according to Markby. Primary duty, secondary duty, and sanctioning one. So the word primary duty means that duty which exists independently of any other duty. An example of primary duty is to forbear or refrain from causing personal injury to another. This is the example of primary duty. Then comes a secondary duty. Secondary duty is that which has no independent existence but exists only for enforcement of other duties. An example of this is the duty to pay a person damages or compensation for the injury already done to the person. Okay, and sanctioning one, as we know, is about imposing a sanction or penalty on a person if committed wrong. So Markby here, while defining liability, talked about it as a condition of a person who is having duty to perform. Like, let me cite one example to make it clear. Like, if B caused injury to A, what was the primary duty of B? It was not to cause injury to A. But as the injury has been caused now to A, what is the secondary duty of B now? To compensate A and to bear the liability by accepting penal procedures. And what is the sanctioning aspect here in this example? To accept the punishment. Like in Indian Penal Code, we have a separate section for injury. Section 44 of Indian Penal Code. It says the word injury denotes any harm whatsoever illegally caused to any person in body, mind, reputation, or property. And also we are having section 323, punishment for voluntarily causing hurt. So according to Markby, we can say the performance of the duty is important. When the wrong will be done, the liability will arise, no doubt. But we also have the primary duty not to cause wrong to others. This is important here to be noted. Now, according to Professor Dicey, Albert Vane Dicey, who was a British jurist and constitutional theorist. So according to him, a duty is a species of obligation. A duty is a species of obligation. People obey it due to indolence, deference, sympathy, fear, and reason. The breach of duty is imprisonment or fine. So let us see duty from the perspective of our topic liability by citing Dicey here. Okay. Now, Dicey said, a duty is a species of obligation. Obligation means an act or course of action to which a person is morally or legally bound. Or according to Collins Dictionary, they say if you have an obligation to do something, it is your duty to do that particular thing. So, according to Dicey, we can say as duty is the species of obligation, then obligation is the genus. Genus means a general class or division comprising several species. Like if obligation is the genus, duty is one of the species of obligation. as duty is coming from obligation. Then Dicey said people obey it, that is, people perform duty due to indolence, deference, sympathy, fear, and reason. So we may ask this question, why people obey duty or perform duty? This is the question. The first thing according to Dicey is to avoid indolence. Indolence, that is inactivity. Because if duty is not performed, it will amount to wrong. It will cause violation of another individual's rights. Like if a person is negligent to perform a duty, let's say a person's duty in his official capacity was to keep a water reservoir clean from industrial waste. But let's say that person did not do it due to negligence. Here suppose due to this the water became polluted, and due to this fish in the reservoir died, and it caused financial loss to the owner of the water reservoir. So here duty is to be performed. Duty is to be performed to avoid indolence. Otherwise, it will amount to liability. Then Dicey talked about deference, which is in easy language. In easy language means polite submission and respect. Duty is performed as a sign of respect, like it is the duty to respect the national flag of the nation. So here it is an outcome of respect. Otherwise, wrong will be committed, which will give rise to what? Which will give rise to liability. Then Dicey talked about sympathy, that duty is also performed as an expression of sympathy. To me, sympathy here can be replaced by the word conscience or let's say sensitivity. Like we have to protect our environment, and we are having Environment Protection Act 1986 for that. Now see, to protect the environment is our duty. It is an outcome of sensitivity towards nature. But let's suppose a person causes harm to the nature. Then for the wrongdoing, there will be penalty. As it is said, if there is a wrong, there is a liability. Like penal provisions are there under the Environment Protection Act of 1986, with imprisonment up to 5 years, or with fine, or with both. And people also follow duty because of fear and reason. Like in despotic country, duty is performed out of fear. And reason is applicable when a reasonable man knows that the non-performance of the duty will cause liability. So to avoid liability, duty is performed. To avoid liability, duty is performed, and if duty is performed, wrong will not be committed. Like, for example, if there is a contract of sale between A and B, let's say A is the seller and B is the buyer. The duty of the seller is to transfer the possession and ownership of the good to the buyer, and the duty of the buyer is to pay the price of the good in cash. If let's say B, the buyer, refuses to pay the money, then the buyer has done the breach of contract or committed violation of contract by not performing the duty. As the buyer did not perform the duty towards the seller, it will give rise to civil liability of the buyer to compensate the seller. Okay. Now let us come to John Austin. Now according to Austin, liability consists of those things which a wrongdoer must do or suffer. I am repeating this again. According to Austin, liability consists of those things which a wrongdoer must do or suffer. It is the ultimatum of law and has its source in the supreme will of the state. Liability arises from a breach of duty, which may be in the form of an act or omission. Liability arises from a breach of duty which may be in the form of an act or omission. So according to Austin, liability consists of those things which a wrongdoer must do or suffer. Which a wrongdoer must do or suffer. For example, let me cite one example. If wrongdoer has committed a breach of contract, let's say, that person must compensate the aggrieved person. It is the ultimatum of law and has its source in the supreme will of the state. An ultimatum is a warning to someone that unless they act in a particular way, action will be taken against them. So law is here giving the ultimatum, and it is the supreme will of the state according to Austin. Liability arises from a breach of duty, which may be in the form of an act or omission. How liability arises? Here Austin is talking about this. When there will be breach of duty, liability will arise out of it. Now two things here we have to keep in our mind. Number one, breach of duty arises in the form of act. Number two, breach of duty arises in the form of omission. Now in the first case, that is breach of duty arises in the form of act, we have discussed about the breach of contract of sale as an example which will give rise to liability for the wrongdoer. In the second case, Austin talked about omission. Now omission in simple language, it means not to do. Omission in simple language, it means not to do. Like if a person's duty is to keep the drinking water tank clean every day by proper treatment, but if the person out of, let's say, negligence does not perform his duty, which let's say caused waterborne diseases to everyone in the locality, here the person caused breach of duty by omission, that is by not performing the duty or not doing the duty at all. Okay, so in the next lecture we will discuss about different kinds of liabilities. Okay, thank you.